and welcome to a new web presentation organized by the Latin America Interest Group of the American Society of International Law. And today we are pleased to have with us Monica Feria-Tinta to give a presentation on the cases of the Latin American states before the International Court of Justice, and more generally about the contribution of the Latin American states and the cases they've had before the International Court of Justice to the development of the jurisprudence of the International Court of Justice. Monica is an experienced public international lawyer. She's worked on many of these cases at the International Court of Justice, both because she's worked at the court and also because she's advised governments on the various cases that they've brought before the court. She has also worked among other relevant positions as an assistant legal advisor of the Foreign and Commonwealth Office of the United Kingdom. And currently she practices as a barrister from 20 Essex Street Chambers in London. She's been the recipient of multiple awards and recognitions, so we're very honored and pleased to have her presenting for us today. And of course, like I said at the beginning, she's an expert on the subject. I should just make a short disclaimer that, of course, the views expressed by Monica in her presentation are her own and do not represent the views of any of the states that she refers to or any of her clients, nor do they represent the views of the American Society of International Law. But with that short disclaimer, I'm pleased to give the floor to Monica for her presentation. Welcome, Monica, and thank you very much.
Thank you very much, Cesar, for that introduction. The title I decided to give to this talk, to this presentation, was Latin American States Before the International Court of Justice, the Latin American Influence in the Development of International Law. And I'd like to start with a quote by James Crawford when he gave his Hague Academy lecture recently called Change, Order, Change, the Course of International Law. And what he said in that lecture was that the present situation of participation in the international legal system is untidy and is far from Hersch Lauterpacht's vision of the individual as the ultimate subject of international law. There is an expanding range of actors in the international system, but states very much remain the key holders and gatekeepers of personality. And because of that complexity of how international law is made, and I want to focus on this last remark, states very much remain the key holders and gatekeepers of personality, is that I was inspired to focus on Latin American states before the International Court of Justice. Having said so, however, I hope that at the end of my talk, you will be aware that international lawmaking has been even more complex because what we have ended up with is being on a contribution of a number of subjects, which eventually end up going onto the positions that the states eventually take up in international cases. So I'd like to start by giving perhaps some introductory remarks and trying to understand what is the importance of international law for Latin American countries, this as context. And I am perhaps inspired to do this little exercise by the efforts that Anthea Roberts made in ascertaining how international law is. and how interesting it would be to look at international law from the eyes of others. So we are the others in her speech. and I think it's interesting to have a little exercise to understand what is the reality of international law when we look at Latin American states. Now, the engagement of Latin American states with international law is very different from the type of engagement other big states may have. For example, states like the UK or like the US. So looking at the region itself, we can see, for example, Latin America is a region that is big in natural resources, very rich in natural resources. So type of cases that have emerged from the region are boundary disputes, both territorial and maritime. Quite key area as well, use of force. And in fact, we will see later how Latin America contributed with a major precedent concerning use of force in international law, the Nicaragua case. We have had, obviously in the region, is also quite relevant to refer to investment arbitration disputes. International law is relevant to Latin America very often in that case, and there is an engagement also with the domestic systems as a consequence. Environmental issues have also been quite relevant in the context of Latin American disputes. And finally, we have human rights disputes. And why is that so? I would say human rights disputes have been major in the general spectrum of international law and Latin American states. And you have to see that in context. And that means we have had a number of dictatorships historically, like Chile, Argentina, Peru, in Bolivia, in Paraguay. And we have had lots of civil wars. Colombia, Peru, Guatemala, El Salvador. And so we have, to a certain extent, very young states and very young democracies. And there has been, we haven't had, Latin American states have not engaged so much in interstate war, but rather we have had a predominance of civil wars. So all of these have been shaping the kind of disputes that are likely to arise from Latin America. Now, how much international law features domestically? Second question. Well, it is interesting to realize that most Latin American countries have constitutions that actually follow the monist system. International law should be directly applicable in domestic systems. Now there has been some reforms, and it's not always the case. But generally speaking, international law can be invoked and can be applied sometimes even at a constitutional level, so it has the same hierarchy within the domestic systems. Now, that reality contrasts, or that legal reality contrasts with how often do national courts actually engage at all with international law. And what we know is that very little. So in my experience, that really perhaps narrows down to jurisprudence that may come from the Inter-American system. So this is the kind of jurisprudence that does feature in domestic law jurisprudence. So why is that so? The Inter-American Court of Human Rights has been extremely important in how it's been influencing and shaping the domestic systems because of this interaction, this corrective kind of role that international law plays. And it has been rather fundamental. Now, I mention this because it is relevant for the cases that we are going to discuss later and the International Court of Justice. So we, in other words, this is interesting. That is what happens in Latin America. You see, by contrast, in places like the United Kingdom, a big part of what you study as an international lawyer will be also international cases that have been litigated and adjudicated by domestic courts, but that have an international law content that will be relevant for international law. And that there's a variety of cases as such. But obviously, Latin America is very different. Latin American states are not, for example, participating in foreign missions. There is no, therefore, an issue of the extraterritorial application of treaties that have been signed and ratified by Latin American countries, although there has been some discrete cases on that. And generally speaking, rather, the figure is the opposite. Latin American states tend to appear as defendants in some domestic courts abroad, in foreign courts. And I think it is worthwhile perhaps mentioning that that could be interesting to notice, however, that some of these type of Latin American subjects appearing in foreign courts nevertheless have created major shifts sometimes in the law. To give you one example, the law of immunities has been tested on the basis of a Latin American subject. The Pinochet case marked a before and after when it came to the law of immunities, and generally speaking, and it was in a UK court. So generally speaking, you could say that Latin America has produced also some shifts, I would say, some conceptual shifts, which we at the beginning, when they were happening, there was somehow states who wouldn't look at it with very good eyes. I remember very well when, for the first time, the Inter-American Commission on Human Rights dealt with the topic of international humanitarian law and human rights law as having connections. This was seen by different institutions, including the ICRC, the International Red Cross, with some mistrust, and there was a lot of criticisms as to, are they doing the right thing? The position back then was, no, this is international humanitarian law, is lex specialis. You cannot, as a human rights law court, interpret that in the context of the interpretation of a human rights treaty. Now, how far we have gone from that? So, it has been about 20 years since that, and now it is a major area, and that is accepted everywhere. And for example, here in the United Kingdom, the Supreme Court has dealt with a number of cases where precisely is being decided on the basis of how these two areas of law actually come together in the protection of individual rights. Another point that could also be interesting to note to some of the contributions and how certain experiences that were originally taking place in Latin America eventually makes effect to go to other regional systems of adjudication is the notion of disappearance, to give an example. So when the Pinochet case was being decided here in the United Kingdom, it was undercut under the Convention Against Torture. So it was quite important, the definition of torture there, etc. But it was a case about disappearances. And so disappearances was the institution, that bottom line we were discussing back then. And yet the United Kingdom had no experience with disappearances. There was just no understanding of what was that. And in fact, the practice defied legal imagination, because there was no way to actually describe it in legal terms, and all the statutes here did not actually cover that, or cover that in various different ways. So there were mentions of things such as forced imprisonment, etc., etc. But the actual practice itself and the elements of enforced disappearance, escape and defy the legal imagination of any judge sitting here in the United Kingdom as a judge. So in fact, eventually that notion of disappearance was not so. It was not really reflected in the judgment. So eventually became a case on torture. But I think I remark this because back then for me it was very interesting to notice, and we had obviously in the inter-American system cases that dealt with that, such as the Velázquez-Rodriguez case, and nowadays the European Court on Human Rights is dealing with cases on disappearances. Now disappearances is not a unknown term in the United Kingdom because of the ICC, the International Criminal Court, and the Rome Statute. And so many of these international crimes now have been incorporated in domestic legislation. And that means that we have had also because of extraterritorial application of treaties, we have had some cases, some claims in the United Kingdom that raise issues such as disappearances, and for that, so that is all this wave effect and how the region itself, the Latin American region, dealt with certain practices, typified them. There was leading jurisprudence on that, and then that is what went all the way to affect the international system as such. So you have that. But we also have had moments where Latin American states and Latin American systems had to catch up with international law. And international law helped in a way to correct certain limitations and failures of the Latin American system. And in particular, I may mention one, and that is what it has to do with violence against women and gender justice. So whereas all the war crime tribunals had already developed great jurisprudence on war crimes and violence against women, ascertaining the illegality of these and acknowledging rape as a war crime. The same didn't happen in Latin America. So I mentioned to you before all the situations of civil war in Latin America. So war, it was a phenomenon very well known by Latin American societies. So eventually the system catch up, and I had the privilege to be instrumental to that when I litigated the Castro prison case. It was the first time that the court acknowledged that the American Convention prohibited, well, in a way, gave the Inter-American Court went as far as accepting a perspective that was a gender perspective to interpret the American Convention on Human Rights, and that was in 2006, and it was the first finding on rape as well, acknowledging that it was a violation of the convention and also crimes against humanity in that context, in the context of the case. And from that moment on, we have had many other cases that have developed similar approach. So we have experienced the feminization of international law in the Americas. So it started with catching up with what was happening in other international tribunals, bringing that to understanding our own international law in the region. And now, obviously, because when the American Convention is such a powerful treaty when it comes to and the jurisprudence has been, I think, very thorough and very good in that sense, that now that is having an effect of cross-fertilization, again, because of the developments and the case law that has been produced there. So this is the general panorama. And how Latin America in different ways have been engaging with international law. Perhaps a last comment that I like to make when I was mentioning that Latin American states tend to appear actually as parties in in foreign courts. In a way, it's also because commercial law and is obviously very important in certain jurisdictions, and there is a very strong legal tradition and practice, and states appear often in this type of commercial cases. and that is the case very often in the United Kingdom. The Latin American states are defending interests before UK courts. And this can also is the case sometimes in arbitration, where Latin American states appear in both in commercial and investment cases. So in this panorama, how does the International Court of Justice fits and Latin American states before the court? There has been a couple of attempts already, and I like to say that if you are interested in doctrinal discussions in the doctrine itself of what Latin American states have contributed to the doctrine of international law, you should listen to the presentation, the lecture of Judge Cansao Trindade for the UN web, which is a very interesting account of that since the last 2 centuries. I'm rather going to focus in a more practical way on the actual jurisprudence of the court, but not just on Latin American cases, but rather on those that Latin American states and Latin American law has influenced. So I like perhaps to focus on the most interesting aspects of it. First of all, a couple of comments on maybe some general remarks on that. I propose that there are certainly about 3 key moments. When I look at those 3 key moments, I can see how dynamics already start appearing. Latin American states have been twice in cases against the United States. One is the Nicaragua versus United States case. Second, I think it marks also a very important moment, and you will see why I'm saying this, is Mexico versus United States. A case concerning consular rights. And finally, I like to mention the importance of the Chagos recent case, which to me is marking also a moment of shift. And I mentioned that, and I'll go back to that later. Latin American countries participated in that advisory opinion. They appeared, and quite a good proportion of Latin American states did so. And it shows that issues of self-determination, issues of decolonization is an important subject, and it's a subject to watch. And Latin American states contributed to the position of how international law looks at that nowadays. Now, in terms of other little remarks, procedurally speaking, I like to say that most Latin American states do appear before the court, and then let's perhaps acknowledge something that Cansao Trindade has remarked, and I believe that it is key, and this is the very fact that Latin American states, because they are smaller states, they are not powerful states, they have a big commitment to peace dispute resolution. So this has been already the case, and we can identify some of the key observations of Latin American states already in 1907. And I think that this is the key. This is a key contribution that Latin American states made to already having the possibility of going to a court to adjudicate disputes. Cansao Trindade points out that history very well, and also how the very rule that allows us to have the possibility to access the International Court was a proposal by a Latin American diplomat in the context of discussing, whether at all it was possible to have an international court. So that is at the very basis of this commitment that Latin American states have had to the International Court of Justice. Now, Latin American states, I mentioned, do appear, and why? Because sometimes there has been states that do not. Right, there has been, though, a recent example in which a recent case, the Guyana versus Venezuela, which is ongoing, where the state of Venezuela had decided not to appear. Now, this is a very sui generis situation. Usually, Latin American countries do, and it's a pity that is happening in that case, which is going to be an important case, I believe. But it's interesting also that is to note that it's going to deprive us a bit of something that could have been interesting to have seen, debated and decided on, which is that Venezuela was arguing, among other things, and there is some newspapers reports on that, that ExxonMobil was helping Guyana to pay legal fees, or that was financing the case. And it would have been interesting, you see, when we talk about investment arbitration and third-party funding, the importance of nowadays of transparency and of making it known to the arbitral tribunals that this is happening. And in this case, I guess it would have been interesting if Venezuela had been had appeared. It would have had all the right to ask, for example, for disclosure and for wanting things to be transparent, whether at all there is any funding on the part of a third party in the case. So this unfortunately won't happen because Venezuela decided not to participate. In terms of a last point there on the general remarks, in terms of compliance, I like to also say that compliance has been generally good when it comes to disputes, and Latin American states have been involved. There are obviously some exceptions. Now we know that the ones that involve the U.S. Unfortunately were not that successful. In the case of, well, Nicaragua and United States, eventually it was Nicaragua. United States contested jurisdiction. Eventually, Nicaragua, with the new government, decided to waive that entitlement it had to the payment of reparations. In the case of Mexico, recently, the Avena case, 10 years later, the U.S. had not complied with the decision. There has been also some hiccups when it comes to interpretation of decisions, and recently there was the case concerning Colombia, where there was an argument that it couldn't be complied with, etc., etc. So, but apart from that, there has been a general acceptance of the decisions of the court. Now, I like to say concerning the jurisdictional aspect that in 1986, the proceedings introduced by Nicaragua against Costa Rica and Honduras was the first time that the Pacto de Bogotá was applied. But since then, the Pacto de Bogotá has been invoked in most of the disputes involving Latin American states. And there has been a number of them. Nicaragua has featured in quite a few of them, against Honduras, against Costa Rica, against Colombia. And there has been also the limitation of the continental shelf between Nicaragua and Colombia. The limitation of the Caribbean Sea and the Pacific Ocean between Costa Rica and Nicaragua, and land boundary in the north part of Isla Portillos between Costa Rica and Nicaragua. Now, I like to comment on different themes that I see that in particular, because I feel that is those areas are quite important in terms of what is this jurisprudence leaving us with. And I'm not going to be speaking about maritime dispute resolution territorial claims, which are the most traditional claims. But I'd rather like to go on to the other areas, because with the recent cases of Guyana and Venezuela, and perhaps the most recent one of Guatemala and Belize, the region has had very much been delimiting and clarifying boundaries. So the next generation really of cases are about something else. And it would be interesting to identify what are those. So going back to the original case that was whose influence has been major in a number of areas of international law, is the Nicaragua case. And here I want to put perhaps forward the topic of use of force. Now, Alain Pelé marked that the deep influence of the judgment has exerted so far in numerous fields of international law is something that hasn't lost its strength, its force. And I think here he also remarked that Nicaragua awoke the court. I mean, Nicaragua played a considerable role in awakening the court from the semi-lethargy in which the court had fell since 1963, because no proceedings were taking place for a number of years, between 1963 and 1966, between 1968 and 1970, and finally between 1977 and 1980. Now, it appeared at a point where the confidence of the third world, so to say, had been lost because of the unfortunate decision of 1966 in the Southwest African case. I think this is interesting because, and that's why I mentioned the Chagos case, because so that was a turning point. Nicaragua brings this case, and I'd say that the confidence of Latin American states in the international court is showed in this recent participation of Latin American states in the advisory opinion concerning Chagos. So clearly the court has not been failing states, has not been systematically taking the side of the strongest. It has shown impartiality, to be an impartial forum for resolving disputes, and I think this is a key first observation that we can make. Now, something that Nicaragua Ambassador Arguello stated during those proceedings was quite interesting, and it takes us back to the very remark that Judge Cansao Trindade had made on the doctrine of international Latin American countries and international law. So Ambassador Arguello said, "The case of my country is also the cause of all the small nations on earth who see in the rule of law their only means of survival." So this embracing the court, because obviously if you are going to be disputing something, it's better to do that in court and not by means of use of force. Now, it is interesting that, well, this case was precisely about the use of force. Now there are a number of issues that could be said about this case, but perhaps I want to focus on use of force, particularly because of the current context. And I'd say that, I mean, since 2011 to nowadays, the entire field of use of force has changed notably. And there are new doctrines. I mean, we have lived in the last weeks we have seen very, very frightening events concerning use of force and new ways of actually exercising force. And that's why I go back to some of these findings of the International Court of Justice back then. And so that's why I believe that this decision maintains its seminal importance. It is current. It is law, and perhaps is valid to actually revisit that and to understand its current validity and the principles that were upheld back then. Now. The rules of general international law that were affirmed then on the non-use of force were affirmed as applicable to all states, regardless of size or military or economic progress. And I think that is, I think this is a very important point in the case. So basically, nobody is above the unlawfulness of the use of or threat or force under international law, and on the illegality of interfering with the sovereignty and political independence or territorial integrity of another state. Supposing there, perhaps moving on to a different area of law is the I would say is somehow influencing and changing conceptions that were rather traditional on the way how international law were looked at, perhaps in some of the most conservative areas that we know purely interstate, such as consular law and the Vienna Convention on Consular Relations. Now, there has been some observations about these, and I'm going to put it under a little chapter that has to do with the changing nature of claims that are being presented before the International Court of Justice. So if in the past we had almost no human rights law in the cases of the International Court of Justice, that has been changing progressively and slowly. But one of the starting points was, for example, in the consular cases. Now, the first case that perhaps brought it to full light was the Lagrand case. Now, the Lagrand case was not Latin American states case. It was a case between Germany and the US. But and there has been some observations that perhaps the Brear case, which was concerned Paraguay and the US, had a key influence on the decision, on the position that the court adopted in that case. But I'm afraid not. What really influenced that decision was the advisory opinion before the Inter-American Court of Human Rights, advisory opinion 16, which was decided in October 1999. The Lagrand case was being decided, the hearings were taking place in 2000. So this is an interesting example because I happen to be involved in that case, and I think it's interesting because Germany was acting, brought the case against the United States very unwillingly, in the sense that they remarked before the court that they had been allies of the US, but they felt compelled to do this, and they proposed an interpretation of the Vienna Convention on Consular Relations, in particular of Article 36, that was very novel at the time in an interstate context, because the United States ascertained that that convention was about the rights of the states and not about the right of individuals. And Germany, in contrast, said that that convention, yes, it was about the rights of the states, but Article 36 also gave certain rights to individuals. Now, the Inter-American Court had dealt with the advisory opinion, which was actually requested by the United Mexican States in October the year earlier, whereby the court make a thorough analysis. Interestingly, the court analyzed the interpreted a convention that was not a regional convention. It had to interpret a UN convention, but to the extent that was relevant to the actual obligations, to ascertain the obligations of the Latin American states, or the states that were within that region. So it was accepted that actually the right to due process is part of those consular rights. And this is very interesting because United States opposed vigorously that the position of in any way acknowledging individual rights under the Vienna on consular relations. However, it was the position of Germany that won, and I assisted Germany in developing those arguments under the convention on the basis of some of the points that had been acknowledged by the Inter-American Court of Human Rights, and that is the position that won before the court. Obviously, after that, we had the Avena case, which followed the same line, and there was from that point on somehow a humanization, you know, of a convention that before had nothing to do with individual rights. Now, how far is that going? It is interesting because, and this is something that Bruno Zima has observed, that if in the past human rights were an incidental topic, and I would say were an incidental topic in the jurisprudence of the ICJ, now human rights are becoming more prominent. They're featuring more prominently in the court's docket. And this important trend was acknowledged, has been acknowledged by publicists like Bruno Zima, who was also a judge before the International Court of Justice at the point. And this can be seen, this trend is continuing with, we can see all these recent cases. The Qatar blockade gave rise to a number of applications that first started with before the ICERD, and then went to the International Court of Justice, and those cases were, you know, basically about human rights. I mean, the provisional measures were all about the protection of human rights. And as we will see later, we are having also now even cases on reparations, and are going to be very much about human rights. So in other words, human rights are becoming more often mentioned in the jurisprudence of the ICJ and Latin American states, and what has happened in the region and at the regional level, and the regional courts had an influence in concepts and how individual human rights are intertwined with international law and general international law in areas that before it was thought it couldn't be possible. Now, a further topic I'd like to touch on briefly is issues concerning the environment. Environmental law is very much the future of international litigation. I think there is a rise on that. I have written about that. And we have on that also a bit of the imprint of Latin America. We had obviously the key case on transboundary harm concerning Argentina and Uruguay that set a number of important precedents, which are extremely relevant, I would say, even to consider in the future possible claims, possible cases concerning climate change. Transboundary harm is being applied in different contexts, and I believe that that seminal case is going to be key in many future cases. So a state is obliged to use all the means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction, causing significant damage to the environment of another state. It is also relevant to mention, apart from that, the recent case concerning Central American states, whereby the court, for the first time in history, decided that it was pertinent to actually make an award for reparations. And so reparations for environmental harm had not happened before, so it was the first time ever that this took place. And this point of reparation, I think, is going to be crucial. So, although reparation as a subject is something that we have mentioned a lot, spoken a lot in the context of state responsibility when it comes to the work of the ILC, etc., International Law Commission, in practical terms, there is very few interested cases where actually there has been a award for reparation, a judgment ordering reparation. Now, in this case that I mentioned concerning Nicaragua and Costa Rica, there was the first ever order for compensation for environmental harm, and that's one example of reparation. Now, the Tribunal for the Law of the Sea has also not long ago issued other landmark decisions, perhaps not on in environmental law and reparation, but in other areas, whereby also has been orders of reparation being made. But I think that the key case that is showing how novel the whole topic is for the ICJ is the recent Congo versus Uganda case, where there's going to be a phase on reparations because both states couldn't agree on the reparation that had to be paid. Now, I believe that all the inter-American, this is a case where there has been human rights violations, and now I believe that all the jurisprudence of the inter-American system on this type of practices, crimes against humanity, bodily harm, etc., is going to be relevant to understand reparations in a case of this type. And this is where you can see how the law that has been developed in the region is going to be somehow influential in the sense of developing an approach to reparations in this context. And this is of particular interest because, as I mentioned before, where compensation has not featured heavily in the ICJ decisions, and this has been, but we are now seeing some major interesting changes. Now, a last but not least point that I should mention, in the direction of how all these contributions are taken, is on the point that I mentioned on Chagos. So Chagos' case, I think, marks somehow a very interesting juncture because, you see, this is a very different court. It's a court which it has a different composition. It was decided under a presiding African judge. And during the proceedings, there were a number of Latin American countries that participated: Guatemala, Argentina, Cuba, Nicaragua, Brazil, Chile. So this case showed the importance of the topic of decolonization for these Latin American states. And we can see, in fact, that the case that I mentioned concerning Guatemala and Belize is really is a territorial dispute, but it is really in the context of decolonization in Latin America. So it is an important topic. I can see that decolonization before the International Court of Justice is going to be this is just the beginning. I think there's going to be more cases of that sort, and certainly with parties of other regions. But the cases and the way the law is being shaped now in the 21st century on that topic is going to be very relevant for deciding those cases. So I'm very much, I like to leave that there, to pause there. I'm very much looking forward to see how the dispute between Guatemala and Belize develops, and see where the new cases that are going to be brought on the topic of self-determination, decolonization before the International Court of Justice. So I like to leave it there. I think that these are the different areas that are clearly showing an influence of Latin American states lawmaking in the region and participation. So we're having self-determination, decolonization, we're having reparation cases and reparation issues. We're having environmental law being prominent in the jurisprudence of the court, and we are having human rights law as pervading many different areas that before were quite insulated from that, and we are having perhaps the important topic of use of force and the prohibition of use of force on the classic Nicaragua versus US case, which I think is very relevant today as ever. So thank you very much for listening.